Welcome. Good morning. It's Truth and Transparency all day. Friday, Fangirl Friday. Let's get started. Today's first episode on Fangirl Friday, Scott Peterson. Yes, I love that people are starting to talk about Scott Peterson. So kudos to them. Defense Diaries, check them out. They're starting to talk about Scott Peterson. Also, Bob Mata, he revamped his whole the Gacy tapes. They have a new podcast out, Buried. Check it out. So there you go. Love to see that people are talking about the Scott Peterson case. Now, while people are going to be talking about it, your girl over here has been going the extra mileage. Here's the extra mileage that we're going to kick off with. Well, I want to show you guys, this is proof of this new loan recorded in 2003, Wells Fargo Bank, 50 G's, the Medinas, a loan amount for $50,000. They did a secondary lender credit line, equity credit line for $50,000. The last time I did something like this was in 1993, so 10 years prior, and they asked for $25,000. So this would have been almost 1 month and some change after the burglary that they hit up, and they need an equity line for $50,000. So next, Scott Peterson, in his amazing filing with his and through his team, police seeking to verify trip story. This is what was in the paper back in 2003. Zoom in. Good morning, everybody. Police seeking to verify the trip story. On January 3rd, 2003, the police reported that they were trying to, quote unquote, verify my trip story about going fishing. The next day, the same day, David Johnson called and told police to contact Yuri, who had information. The police announced they were searching the Berkeley Marina. That was the area they were searching for Lacey, and that the quote unquote police boats carrying Cavender dogs are scurrying the Berkeley Marina this weekend searching for Lacey Peterson. The headlines in the newspapers within days of Lacey's abduction made it clear to the world that the police suspected I was responsible. This is absolute craziness that you would be giving up somebody's alibi. And so here's a picture. Investigators refused to say if husband was asked to take a lie test as well. And police seeking to verify trip story. Public being asked to report if husband's truck / boat were seen. You guys, all these people did was come forward, okay, and tell them that we did see his boat. We did see a guy that could not back up his trailer, okay? Everybody, if you are a boater, that stuff sticks out to you because it's, God, it's so frustrating if you're a boater or jet skier and you're going to drop off your, the launch and you get behind somebody that doesn't know what they're doing. It could take like an extra 30 minutes. You just like sit there. Anyways, this is what was in the paper. And this is absolute crazy. Like, this wasn't like, we're not talking about 1970, 1980, 2003. This is what was in the paper. Unbelievable, right? And everybody wants to know what Mark Geragos has said in support of this petition and what the mailman, okay? Like, how could Mark Geragos mess this up so badly, in my opinion? Okay. If you know the cops are not on the up and up, and you know the prosecution is not on the up and up, then you know that stuff's being hidden from you, right? And you need to scour through stuff. And they're not asking for things. But I have a question, though. That does not excuse why Mark Geragos would have told the jury, if he didn't know that the people existed that were going to place Lacey Peterson out walking the dog after Scott left, Okay. He promised the jury that you're going to hear from people that saw Lacey after Scott left. How do you not put people like that on the stand? Well, here it is, guys. Mark Geragos' declaration. Okay. He filled this out in 2015. Mark Geragos, the lawyer of Scott Peterson. And I was waiting to read this because I was like, okay, dude, I have so many questions just from a professional standpoint. Okay. How do you do your client so dirty? I don't care about that the police are dirty. Okay. I have to be able to wrap my head around what was going through your brain. Right. Um, Back when, you go off to college, like I did, it was between I wanted to either be a teacher or I wanted to be a lawyer. Okay. I also played 2 Division I sports at the University of Cincinnati when I went off to college. Well, you know the old saying, you're a student athlete? No, you are definitely not in college. You are definitely an athlete student, which I think back. So I was in college when this happened in 2002 when she went and disappeared. And then when she was found in 2003, I was a junior in college. And so I was told by my coaches that, why don't you take criminal justice? I'm like, what? Like, no, I either wanted to be a teacher or a lawyer. I don't want to be a cop. I don't want to be a cop. I don't want to be a social worker. Like, I was like, criminal justice. I was like, and then like, well, then, yeah. And then you can go, like, because I was like going to do pre-law and then go to law school. Well, guess why they talked me out of stuff like this? And teaching, they talked me out of. Because of the time of day that these classes were offered. So for golf, you could pretty much get on the golf course by yourself and go hit balls and do all that. Like, you don't need a team to practice. Okay. But you definitely need to be there when your team is practicing basketball. There is no, you can go, oh, come and get into the gym and get it. No, you got to be there from 12 to 3 is our practice every single day. When we don't have a game and we have one day off a week. And then after our 12 to 3, then we're down in the weight room or doing extra cardio and then study table. And by the time you're like free, good luck if it's before 4 p.m. Okay. So you might as well block off from 12 to 4. That's what it was at. And the boys basketball team, they would always practice from 3 to 6 every day. So we had 12 to 3, they had 3 to 6. And then when I wasn't in season for that, it was golf, and we were always traveling because we never had home matches, which was even like worse because I'm missing like 3 to 4 days per week of school. And so as much as I loved my time there, I blamed, I was like, this is why I didn't become a lawyer, because I had to pick and choose. And guess what time the criminal justice classes were normally offered? Early in the morning or night classes after 6. Teaching, they were always like, the majority of the teaching classes were noon to 3. And then when you wanted to do like student teaching, you're like 7 in the morning until 3. So I just laugh when they say, oh, you're a student athlete. Dude, the university owned you. And then we donated so much of our time to Habitat for Humanity. I mean, you name it, we were always involved in those organizations. And so I love the fact that these athletes now are getting paid. Love it. I love that Caitlin Clark got to experience at the end of her time at Iowa. Caitlin Clark has done so much for women's WNBA. So here, moral of the story is I have questions for Mark Geragos. Because if I was to be a lawyer, I would be like, dude, what the hell did he do? How can you promise? The one thing that you never want to do is tell a jury something and then don't deliver. That you lose trust. If there's anything that I ever learned from a lawyer is the moment that you lose trust or the jury loses trust in you, you are effed. You are effed. Your client is effed. You can never lose the trust of the jury. They cannot think that you're shady, whether you're a prosecutor, whether you're a defense attorney. The jury, they have to trust you. They have to believe when you say something and that you're going to deliver on it. So let's read this. Mark Geragos declares the following. I'm going to make it just a tad bit bigger. I, Mark Geragos, declare as follows. I am an attorney licensed to practice in California. I was lead counsel for the defendant, Scott Lee Peterson, in the criminal case People v. Scott Lee Peterson. On December 3rd, 2003, the Stanislaus County District Attorney filed a 2-count information against Mr. Peterson, charging him with the December 2002 murders of his wife, Lacey, and their unborn child, Connor. The information added a multiple murder special circumstances in violation in section 190.2, subsection A3, which made Mr. Peterson eligible for the death penalty on January 9th, 2004. The state filed its penal code section 190.3. Okay. Now, number 3. In 2003, Mr. Peterson's family hired me to represent Mr. Peterson in this capital case. I first appeared for Mr. Peterson on May 2nd, 2003. Very important date. Here's the facts. Okay. The pre-preliminary examination record at page 5 and 7. Okay. So he was not hired to represent Scott initially. That was McAllister. Kirk McAllister represented Scott at the end of December, right when his wife went missing. Mark Geragos comes on in May. Okay, so it's really, really important. Okay, next. The case was originally filed in Stanislaus County, where Scott and Lacey lived, because that's Modesto is in that county. Because of the extraordinary publicity the case garnered, the Stanislaus County granted a motion to change venue. So they won that. Venue was changed to San Mateo County. So when you hear how Nancy Grace was always talking about San Mateo, I'm out in San Mateo. Okay. She was always out in San Mateo during that trial because that's where it got moved to. The Honorable Alfred DeLucia, judge of the Alameda County Superior Court, was appointed to preside over the case in San Mateo. The change of venue to San Mateo Court or County did not lessen the prejudice to Mr. Peterson from the extraordinary pretrial publicity that publicity continued unabated in San Mateo County, just as it had in the Stanislaus County. I recall Judge DeLucia, who was a veteran trial judge, stating that in his entire career, he had never seen a case with so much publicity and heated public emotion. You guys, this is by far, in my opinion, it blows away the O.J. Simpson stuff. It blows away the Jose Baez case in Florida with Casey Anthony. This case is number one when you want to talk about pre-trial publicity and the mob of mainstream media camping out, following somebody around. And ultimately, think about this. The reason why, okay, is because Lacey and Connor were not found until April 18th. So you have from December 24th, when you have somebody that hasn't been found, just like in the Idaho 4 case, 4 people were found stabbed to death, okay? Nobody's arrested. Then a week goes by and nobody, and what started happening in the Idaho 4 case, everybody's getting on over to Moscow. Everyone's getting on over to Latah County. All the stations are talking about this case because of the unknown. Nobody was arrested, that type of thing. That always is going to heighten, okay? Especially when you have people saying there's a killer on the loose, right? And there's a manhunt. Well, here, it was being spread worldwide that there really wasn't a manhunt. We're waiting to find bodies so that we can arrest Scott Peterson. Okay? That's what it was like for him. He never stood a chance because of the police and how they misinformed on purpose the media. Okay. The pre-trial publicity, almost all of it, was prejudicial to Mr. Peterson. It made for extraordinarily difficult to select an unbiased jury. The statistics were breathtaking. They showed that 96%, number one here, 96% of the potential jurors, a total of 939 potential jurors. Holy, okay. So I've been to Delphi. They were going to have 600 potential jurors, okay? Idaho had set aside that they were going to have 500 to 1,000, okay? So back in 2003, to have a jury pool of 939 potential jurors, okay? 96% of those jurors had been exposed to the pretrial publicity. Number two stat, 46% of that group, a total of 432 potential jurors, had drawn a conclusion as to whether Mr. Peterson was innocent or guilty based on this publicity. What do you think it was? Based on the publicity, it would be that you're guilty. Okay? 46% of those people thought that this man was already guilty. And then, most significantly, of the 432 jurors who had reached an opinion, 98 believed Mr. Peterson was guilty, while only 1%, a total of 6 people, believed he was innocent. 6 people. 1%. How can you win? How can you be acquitted like that? Well, think about this, though. The jury, it took them 3 to 4 days. But remember, people don't know this. When the jury went out to deliberate the first time, well, here, I'll let Mark Geragos tell us about it. In light of these statistics, which indicated that Mr. Peterson could not get a fair trial in San Mateo County, he moved to change the venue again, preferably to a larger and more distant county such as Los Angeles. He wanted to move it to Los Angeles. I recall presenting evidence showing that Los Angeles had the lowest prejudgment rate of any county in the state. The motion was denied. I was therefore confronted with the difficult task of picking a jury in San Mateo where many of the potential jurors believed my client was guilty of capital murder. In preparation for jury selection, each prospective juror filled out a very extensive questionnaire. Potential jurors were screened for hardships and then challenged for cause, including their asserted inability to follow the law relating to deliberations on the death penalty. In addition, prospective jurors were orally questioned by the court and the parties to provide the attorneys with the information on which to exercise peremptory challenges. Both sides were permitted to exercise peremptory challenges. By the time I began to exercise those challenges, I had a comprehensive understanding of each potential juror who was called to the jury box, and the jurors who remained available and could be called to the jury box upon peremptory challenge of any of the jurors in the box. Following the exercise of 16 peremptory challenges, I accepted the jury as constituted. Though I had peremptory challenges remaining, I did not exercise them. My failure to exercise these remaining peremptory challenges, however, in no way indicated that I was satisfied with this jury. I was not. Okay. So he has to put in here, because everybody would be and has said, well, he had more challenges and he didn't use them. So you must be happy with the jury. Okay. For example, I don't know, from what I was told, what they did in Delphi. Okay. And I think they did this in Karen Reed, but they put the 500 people in order based on how the forms were filled out prior to when you had to turn those in. And so they got to go through those. And then it was based on those, especially with Delphi, I believe it was like this, that you had an idea based off of how people were filling out their questionnaires, that you then put them in a ranking system, and then it went like every other one. And that's how it was making up like that 50 pool that would go in at a time at Delphi. So clearly, if you're getting down the list, you know that you put the people that were back further, like they're the people that are just absolute fucking morons to you. Okay. But then again, maybe we need some morons. We need people that are like, that will put up a fight in back in a deliberating room. You can't have yes men, yes women. So he has to come out the gate and say this part because he didn't use all of his challenges. But he says here, I have reviewed the appellant's opening brief filed in Mr. Peterson's appeal by his appellate attorney, Cliff Gardner. In that brief, Mr. Gardner argues that Mr. Peterson's conviction should be reversed because the prejudicial pretrial publicity made it impossible to seat an impartial jury. I have been advised that the state has argued in response that since I used only 16 peremptory challenges and had challenges remaining, the inference is that I was satisfied with the jury and believed it could be fair to Mr. Peterson. As I explained below, this was not the case. At the time I had used 16 peremptory challenges, my motion to change venue from San Mateo County had been denied. I had questioned all the jurors who had passed through the voir dire, and I had reviewed their jury questionnaires. I was trying to get the best jury possible for Mr. Peterson of the jurors I was being forced to choose from. Very, very important. Okay. So he's telling the courts, listen, I knew what we were working with, 936 people. At that point, when you tell me that I cannot change venues, this is who I am stuck with. I need to pick the best possible people from this pool. Okay. It does not mean that I'm this is, you denied me my change of venue a second time. Okay. So I have no choice but to deal with these people. And if I'm coming across certain people before other people, I'm not going to strike them out because I don't want to get stuck with these other names that we haven't even come across yet. And I've already put on my little list, like, no way in hell can this person get on the jury. You get what I'm saying? So this is like a really good insight to the process and what his attorney, Mark Geragos, was thinking. Now, again, I was trying to get the best possible jury for Mr. Peterson of the jurors I was being forced to choose from. Based on the substantial information I had, I believe that the remaining jurors who had qualified to serve but were not yet in the box were not as good as the jurors in the box after I used my 16 challenges. That is the only reason I did not exercise additional challenges, because I'm not going to strike out those people, even though we don't want them. We definitely don't. We want them over the other ones. Okay. This does not mean that I was satisfied with the jury was a fair one. I'm sorry. This does not mean that I was satisfied with the jury was a fair one. I think he messed up his wording there. It only meant that I believe the jurors in the box were more acceptable than those who were in line to replace any further jurors I might challenge. Any trial lawyer would know this. Boom. That's called common sense to me. Moreover, even after the jury was selected, I made a motion for change of venue based on the jurors' pre-judgment of the case. That motion was denied. Good to know. People don't know this. My failure to use the balance of the remaining balance of my challenges thus reflected the reality that the jurors in the box were preferable to the remaining potential jurors I might have gotten had I exercised more challenges. But in no way does it reflect my belief that the jury could be fair to my client. During the guilt phase of Mr. Peterson's trial, the prosecution called Dr. Ralph Chang. Now, this is going to get into the experts, okay? And this is the good stuff for what's going to be coming up. Scott Peterson didn't have the experts, okay? Just like how I've made the example that if Karen Reed doesn't have the experts that she had in her trial, she loses, no doubt about it. I don't care if she had Alan Jackson. I don't care if she had Yannetti, Alessi. It would not matter. If she doesn't have Crash Daddies and she doesn't have La Posado, who else? The guy to talk about the key cycles, she loses. The jury would have saw that John, his phone never moved after they're saying that her vehicle left at the same time as his phone never moved again. And then the light, the headlight or the tail light rather being in a million pieces right there. Now, who is Dr. Ralph Chang? Well, the prosecution calls him. He is a hydrologist to testify as to the movement of bodies in the San Francisco Bay. Dr. Chang's testimony would state his expert opinion that based on the date and time the bodies of Lacey and Connor washed ashore in the bay and the tidal and weather patterns in the preceding days, Dr. Chang believed the bodies had been placed in the bay near Brooks Island. That is the area where Mr. Peterson told police he had been fishing on December 24th, 2002. I objected. Nobody knows this. He objected. So it'd be like Ann Taylor objecting to like, let's say like Amazon Click expert Cox. And she's like, he's not an expert. Okay. So here, Mark Geragos, I objected to Dr. Chang's testimony on the ground that while he may have been an expert in the movement of water in bays and estuaries, he did not possess sufficient expertise to testify as to the movement of bodies in the water. In fact, Dr. Chang admitted that he was not an expert in that precise area, and then cites the transcripts. Mr. Peterson's opening brief on appeal argues that the trial court erred in admitting Dr. Chang's testimony. I have been advised that, in response, the state claims that I waived any right to complain about introduction of Dr. Chang's testimony by virtue of my cross-examination of Detective Dodge Hendy 3 months earlier. So remember, this was a very long trial. And so what the state is claiming is that he says, I have been advised that the state's argument is that I opened the door to Dr. Chang's testimony when I questioned Hendy about the accuracy of Dr. Chang's analysis of where the bodies were placed in the bay. We're going to come back to that. My questioning of Detective Hendy did not open the door to Chen's testimony and was not intended to do so. As I pointed out in the trial court, he shows the transcripts. I did not ask Hendy anything about Dr. Chang's specific prediction as to where the bodies were put in the water. That evidence only came in from Dr. Chang himself. And that was the testimony I objected to. While I did cross-examine Hendy, my cross-examination was limited to the subjects he testified to in direct examination only. Because guess what? That's all you can do. Okay? I did not waive or intend to waive any objection to Dr. Chang's testimony. In fact, the trial court did not rule that I had waived any such objection to Dr. Chang's testimony. Instead, the trial court overruled my objection on the merits. So here you have these state prosecutors and the appellate people that are doing the state's work. And according to Mark Geragos here, it's like they're not being truthful about what occurred in that courtroom in 2003. Next. Mark Geragos goes on to say, during the trial, I objected to the trial court's admission of several other items of evidence and testimony. I have been advised that in its brief on appeal, the state alleges that I objected to this evidence on state law grounds only. Okay. I'm going to talk about the Idaho 4 case here for a second. Go back and listen to every single time that Ann Taylor has ever put objections in, has ever, in any brief that she's ever done. I went and hunted this down, and Ann Taylor did a very, very good job of talking about, and I think she did, that's why they wanted Masseth on the case. Making these objections are also under federal. So go take a look. And but immediately when I read this, I immediately thought of the Idaho 4 case. And so I went and, double checked to see how Ann was filing, her motions and doing her oral arguing. And I think that kudos to her. I believe that she did a really good job of that. So again, Mark Geragos says that I have been advised that in its brief on appeal, the state alleges that I objected to this evidence on state law grounds only, and therefore waived certain federal components of the objection by failing to cite the federal constitution. These are all stuff that you would learn in law school that we learn here now. My understanding of the law existing at the time of trial was that where the federal claim did not require the trial court to undertake a different analysis, citation to the federal constitution was not required to preserve a federal issue. And so he uses People versus Yemen. Based on the law at the time of trial, I therefore believed that my state law objection was sufficient to preserve an objection under federal law, so long as the analysis were the same. Further, to the extent that the state argues that I did waive any federal objections to evidence to which I objected on state law grounds, I categorically deny that I made a tactical decision to object solely on state law grounds. I had no such tactical reason for not objecting on federal grounds. That's important to say. Tactical meaning strategy, okay? There is no way in hell that you could ever argue that that was a strategic move. And I'm putting this in a declaration that I did not do that for a strategical move. Okay? Because that is a big argument that always the state brings and puts forth, is that your trial strategy, or their, just in summation here, who's ever it would be going up against, their trial strategy is their trial strategy. And he's basically saying, if they're trying to suggest that this was trial strategy, they're fucking crazy. Okay. At trial, the prosecution rested its case on 3 types of forensic evidence. This is why and how the LA Innocence Project decided to take on this case, because they do forensic, like the LA Innocence Project, they need forensic evidence to look at to decide whether they're going to take on a case or not. The Innocence Project, the big one, the big daddy, they need DNA to look at a case. So, at trial, the prosecution rested its case on 3 types of forensic evidence, one being the fetal biometry evidence, which purported to show that based on measurement of Connor's bones, he died on December 25th, 2002. 2, evidence of the movement of bodies in San Francisco Bay, which purported to show that based on where the bodies of Lacey and Connor washed ashore and the tides and winds in the preceding days, the bodies were placed in the bay near Brooks Island, precisely the area in which Mr. Peterson said he had been fishing on December 24th. And then 3, evidence of canine scent detection at the Berkeley Marina, which purported to show that a trained dog had alerted to Lacey's scent in the area in which Mr. Peterson launched his boat on December 24th, 2002. All of this is being refuted by new experts that say that stuff is so whack. It's not even funny. It's error. It's flawed. It's wrong. And if Scott Peterson would have had the experts, and if the advancement of things in 2003 had basically been available like they are today, none of these claims could have been made. So it's kind of like the same thing with DNA. If we would have been able to test DNA, right, and had certain things, that's how people get exonerated. We didn't have that ability to do certain things. And now once you do, and then you retest something or you test something that you never tested before, that's how people are getting exonerated. This is no different. Okay. Prior to trial, I recognize the highly inculpatory nature of the evidence of the movement of bodies in the bay and the evidence of the canine scent detection at the Berkeley Marina. I cannot believe that he's saying this. I therefore determined that it was critical to the defense case to preclude the admission of both categories of evidence. As explained below, because the prosecution did not disclose its intent to introduce expert testimony on the 3rd category of forensic evidence, the fetal biometry, so until the trial was underway. This would never fly. This should never fly. Your expert disclosures, expert testimony, okay? There is a deadline, okay? There is a deadline for this. And I'm going to use the Idaho 4 as an example because we're just so used to that case right now. Is that, remember, Ann Taylor's always talking about, hey, you have these dates. And the prosecution goes first with when they're going to disclose any experts. And here's their report on what they're going to testify to. You see what the case is against your client. Then based off of those reports, then you as a defendant go out and get and seek, hey, this is what they're saying. Here's this person's report. How do you see it? Is this how you see it? Is this how you see the evidence? Well, no, I don't see it like that. In fact, I see X, Y, and Z, or these type of conclusions are, no, you can't conclude like that. You can't opine. Or somebody could say, yeah, that's exactly what you would be doing, you know? So check this out. In the Scott Peterson case, according to Mark Geragos, the prosecution did not disclose its intent to introduce expert testimony on that 3rd category until the trial was underway. I had not considered before trial the significance of expert testimony on that issue. The prosecution's late disclosure of its intent to introduce evidence of the fetal biometry through its expert, Dr. Gregory DeVore, made it very difficult for me to respond with an expert of my own. The prosecution was late in disclosing its intent to call Dr. DeVore. The information in this case was filed on December 3rd, 2003. Venue was changed to San Mateo on January 20th, 2004. The court began to hear pretrial motions on February 11th, 2004. Jury selection in San Mateo began on March 4th, 2004, and was completed, look at this, a whole month. So in 2003, they did a whole month. Okay. And Hippler, 1 week in 2025, with the way that everything is. Like, are you kidding me? The presentation of evidence began in this case on June 2nd, 2004. On February 17th, 2004, in the midst of pretrial motions, the prosecution presented me with a list of additional witnesses, including Dr. DeVore. I objected to this late disclosure, stating to the court that the problem is that I believe that under 1054, that's not appropriate for them. At this point, to notice another expert when technically I believe we're in trial. And I don't think that is not somebody who was known to me. This is not a precipitant person. This is not somebody who I believe had anything to do with the autopsy, the examinations of the remains, or anything else. I don't even have a statement as to what this person's proposed testimony is. This is exactly what Ann Taylor was saying that was going on in the Idaho 4 case. Mark Geragos goes on to say that the prosecutor responded that the people obtained Dr. DeVore as an expert after the defense filed a motion brought under Penal Code Section 995, raising the issue of the age of the fetus. The prosecution acknowledged that Dr. DeVore had written a report and that the report, which at that point had not been provided to the defense, would be provided. After hearing argument from the prosecutor, the court stated that the defense was getting, quote unquote, all of the stuff at the last minute. That doesn't give him much time to prepare the defense. That's a problem, end quote. The court continued, I was under the impression that the case was ready for trial, and apparently it's not, end quote. The court stated, however, that it was reluctant to give me a continuance, quote unquote, because we are all here ready to go. So I want to point this out for a timeline. Scott is arrested in April of 2003, April 18th, just the day after Lacey and Connor were found. Jury selection was literally less than a year from that date. Okay. For a death penalty case. At trial, Dr. DeVore testified that based on the measurement of Connor's femur bone and the date of conception, Connor probably died on or about December 23rd, 2002. Dr. DeVore said he relied for this conclusion on equations developed by the fetal biometrist Dr. Philippi Gene T. I think it's Gene T. Ryan Philippi. I wish it was Ryan Philippi. Fangirl Friday. I did not have, Mark Geragos says, I did not have sufficient time to locate an appropriate expert to examine and rebut Dr. DeVore's opinion on the age at which Connor died. I tried to find a qualified expert who could advise me on the validity of Dr. DeVore's opinion, but this was very difficult to do because by the time I received his report, I would love to have known the date. My attention was required for pretrial motions and jury selection. I said, so I take number 32, and I believe that that's an excuse. Okay. I'm sorry, but that is devastating. Like, when you would have ever got this and knowing that he's going to testify based on this, that, yep, the baby's dead, dying on this day. Very, very damaging to your case. So, Mark Geragos says that I recognized that Dr. March was not the best expert we could have gotten. So he's saying, doesn't really give much into this, but Dr. March is the expert that they got. Particularly because his expertise was not specifically in assessing the age of a fetus from fetal bones. Under the circumstances, however, he seemed to be the best we could do at the time. I therefore called Dr. March as an expert to rebut the testimony of Dr. DeVore. In his direct testimony, Dr. March stated, so when it was the defense's turn, you know, like how Karen Reed had her turn, and like how she called crash daddies, okay? Scott Peterson, we called Dr. March. And Dr. March stated that he reviewed Lacey Peterson's medical records, the testimony of Dr. DeVore, and studies on the fetal biometry by Genty. Based on this material, Dr. March concluded that the date of Connor's death was December 29th, 2002 or later. And I'm over here just saying, well, like, how did he determine that? He really, you know, that's just me. I just wanted to know. On cross-examination, so then Dr. March gets cross-examined by the state. So on cross-examination, the prosecutor brought out that Dr. March did not appear to have expertise in the area of the fetal biometry. Instead, his primary expertise was in, reproductive endocrinology. So awesome. Dr. March also admitted that his testimony was given without any background in anthropology. Now, I want to talk about the Idaho 4 case for just 1 minute. You guys remember when I was going through the witness list and I was like, I wonder what they want with an anthropologist. You guys remember that? So keep that in your back pocket when I talk about something that's coming up next week with the channel. That's all. Okay. Okay, his testimony did not succeed in impeaching Dr. DeVore. In light of Dr. March's lack of expertise, the jury was left with the impression that Connor had died on December 23rd, 2002. I have been advised by habeas counsel for Mr. Peterson of the following: that habeas counsel has contacted Dr. Genty, on whose equations Dr. DeVore said he relied. So when the Innocence Project got a hold of this case, they're like, we need to contact this person here because this is who their expert relied on his work. Okay. Dr. Genty signed a declaration for Scott Peterson, this person, on whose the state, hey, I used this man's formula from 1982 or 1984. So, but they got the big dog here, Genty, to sign a declaration for habeas counsel in which he stated that Dr. DeVore used an equation that Genty himself had developed, but that Dr. DeVore used the wrong equation. Okay, I have a question now. What do you think Lana Brains is thinking right now? Why in the world, if I would have seen, so in 2003 and then 2004, if I would have seen as a lawyer that this man is going to testify to, so that Dr. DeVore is going to testify, and he's over here taking this man's, the Genty dude, you would immediately go to Genty right away. Like, this to me is just, is this common sense? Or am I just like, you guys, I would have seen a report and he's over here telling me that how he's getting to his December 23rd date, okay, is he's using this person's formula, equation, by measuring the bone, and it's going to tell you how many weeks and blah, 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 that the baby, all that stuff, right? It would just seem to me that it would be common sense that that's who I would have went to immediately to see, because I would want to know. Remember, I think the police are shady. Okay. I think the prosecution's shady, right? That means anybody that they would be bringing in as an expert, they could potentially manipulate to get them to say whatever the fuck they wanted. Okay. So I need to make sure that that person couldn't have been compromised, that Dr. DeVore couldn't have been compromised. And so I don't know anything about this stuff, right? Well, guess what you do as a lawyer? We need to talk to this Genty guy. Can you get him on the phone? And I would need to set up a meeting immediately. That's what I would have done if I was Mark Geragos. And no, the moment I read this, I didn't have like days to think that that's what I would have done. Immediately, that's what I would have done. Like, there's just, it's just. So I would like to know more about that. But anyways, big bomb here is that this dude is like, he did it wrong. And so Mark Geragos says that Dr. DeVore used the wrong equation and applied it to the wrong bones. That had Dr. DeVore used the correct equation, as Dr. Genty did, the date of Connor's death could have been as late as January 4th, 2003. And that date is so important because of the January 3rd article. On January 3rd, 2003, the police reported they were trying to verify my story. And so everybody knew, if not sooner than this, but at the very least, it made the papers. And it's Berkeley Marina on January 3rd, and it's trying to seek verification. Meanwhile, they already had verified it. If the prosecution had disclosed in a timely fashion that Dr. DeVore was going to be a witness on the issue of the fetal biometry and timely provided me with a copy of his report, I could have obtained the services of Dr. Genty to review Dr. DeVore's opinion. So I don't see where Mark is writing in here that he didn't receive his report, because now he's saying exactly what I'm saying. Like, which is, so he's making it seem like to the reader of this that I never had his report prior to what? I thought in February of 2004, you received it. The moment that you think a lawyer is lazy, you need to depart. You cannot have a lazy lawyer. I had no tactical reason for not doing so, and only hired Dr. March because of the time constraints imposed by the people's belated mid-trial disclosure of Dr. DeVore and his report. So right here, then he says that he got the report. And I don't know why he's calling it mid-trial, because I'm really confused. Because I'm under the impression that I thought he got it in February of 2004. Trial started in June of 2004. So unless they disclosed his name in 2004 in February, but they didn't do the report part of it. Okay. I don't know how Geragos, though, isn't screaming from the rooftops the day that trial is starting and saying, Your Honor, I have some preliminary matters that need to be handled. I just want to make sure that we're clear here. These are the only disclosures that I have as far as expert witness goes. Okay. I have these names and I do not have any reports from blank, blank, blank. Or so if I need to put a motion of limine in right now, I mean, what would you like me to do? Like, if there's anything I've been learning is that you can never not say enough. Just keep putting everything on the record. And that's why Ann Taylor and Massis were getting so frustrated because Hitler was preventing that. Hitler was preventing and always cutting people off. I'm trying to make a record here, sir. I don't care what the fuck you think. That's great. Your job is to referee this. At the end, you're going to give an order. Okay. But I need to put this on the record for my client because this is how somebody would get fucked down the road. Like, Hitler really chaps my ass. So, on the forensic issue of the movement of bodies in San Francisco Bay, the prosecution called an expert hydrologist, Dr. Ralph Chang, to testify on this question. As discussed above, Dr. Chang testified that based on where the bodies washed ashore, that the winds and the tides in the preceding days, the bodies most probably were deposited in the bay near Brooks Island where Mr. Peterson had been fishing. Dr. Chang provided the police with a map which contained a projected path that the bodies might have taken to the shore. And he pinpointed an area in the bay for the officers to search. Wait till I go into more depth about this search. There was a huge area that they could not search due to the depths. It was like not deep enough. So they weren't sending the sonar into certain areas. Anyways, it was 500 to 1,000 yards southwest of Brooks Island and in the approximate area where Scott said he was fishing on December 24th. Dr. Chang had produced a report containing his conclusions. The prosecution provided me with a copy of that report prior to trial. Based on my review of that report and Dr. Chang's curriculum, so like his CV, it was apparent to me before trial that Dr. Chang was not an expert in the movement of bodies in the water. I therefore believed that upon an appropriate motion for lack of expertise and lack of foundation, the trial court would be compelled to exclude his testimony. Dr. Chang's lack of expertise was so clear that I did not believe his expert testimony would be admitted by any court in California. I retained an expert in oceanography. Oh my gosh. So I took an oceanography class at UC, okay, thinking that I was just going to get the easiest A ever in this class. Literally was like, all right, I'm going to the first day, getting my syllabus, not going to be returning unless there's a quiz, a test, a midterm, and a final. Okay. I get a phone call. Like, you don't ever get phone calls and emails that, like, where had I been? I'm like, dude, I read your syllabus. I don't have to attend class. Like, I don't lose points for that, first of all. Second of all, so I didn't even respond to that. Then I go to take a quiz, and I got a D. Like, fucking D, big fat D. And I'm like, what the fuck? Well, here, this guy's like, oh, so you've been just reading your book, huh? Yeah, our quizzes, tests, midterms, it has nothing to do with that book. I said, then why does your syllabus say these chapters and, pointing out some things? He's like, yeah, if you plan on passing this class, you have to be here and get the notes. I said, well, just for the record, I don't miss Totally on purpose all the time. I am an athlete. We are out of town. I thought this was disclosed to you by my counselor, blah, blah. And then I can just read on my own. But why did you give us a book? And why did I have to go out and buy this $200 book? And he's like, well, didn't the university pay for it? I said, yeah, even still, whoever paid for it, why would you, if you're not going to do anything from this book, Why is it in your syllabus? Like, got into it with this dude. Needless to say, I was like, fuck oceanography, man. I was like, I just want to get this easy A. Psh. I was like, motherfuck this guy. It wasn't an easy A. I think I got a B. But when I saw this oceanography, I was like, oh God. The first time, I haven't heard the name oceanography probably since college. But oceanography. Dr. Christopher Kitting, a professor at California State University, East Bay. I asked Dr. Kitting whether he could perform an experiment by dropping a drift buoy near Brooks Island and follow its path. Dr. Kitting informed me that there were so many variables involved, including the tidal and wind patterns and the precise time the bodies became unmoored, that it would be difficult to replicate the precise factors involved in the initial migration of the bodies to the shore. I therefore did not pursue the experiment with Dr. Kitting. My last contact with Dr. Kitting was in late summer of 2004. So he's like saying, I went to one of the experts and good luck. So many variables. Like, anybody that's a professional and an expert in this field would have to say that. Would have to say that there's all these variables. Okay? Like, that's what I would take from that. But I'm also thinking to myself, why not just bring him on to say this? Right? At the very least, at the end of the day, it's called cover your ass. CYA, baby. Cover your own ass. Because Dr. Chang was not even an expert in the movement of bodies in the water, and his method was subject to challenge under the Kelly Fry, I therefore did not believe it was necessary to proceed further with an expert regarding Dr. Chang's conclusions or to have such an expert testify in response to Dr. Chang, and I did not do so. Well, math is my murky. That's why I took it. Math's like my strong suit. I was like, I got this all day. So here I'm like, wait a second. This is a capital case. This man is on trial for his life. And you have a meeting with this guy and he tells you everything that you need to hear. And it would just be like, okay, so we're hiring him. Guess what? I believe that he wasn't hired because of money, which tells me, Mr. Geragos, just come clean and say that you were charging X amount of dollars and the Petersons were running out of money. Because how do you not have this person to come and testify? You would say, listen, if they allow this testimony, I'm going to need an expert for this. But I think that it's not going to be allowed. What can we do here? How difficult would that be? All experts, it's usually that they ask for a retainer. Okay, I'll give you a $5,000 retainer. Probably back then, what, $2,000? I don't know. Now, Mark Geragos goes on to say that, as I had predicted in my voir dire of Dr. Chang at trial, so this is what Ann Taylor was planning on doing to Nick Balance, Dr. Chang acknowledged that his work had never explored the movement of bodies in the water or the bay. Here is his testimony. Question. You have never done any study in San Francisco Bay that has anything to do with bodies or things of that size, correct? That is correct. Further, because Dr. Chang admitted that he was not an expert at all in the movement of bodies in water, he could not factor into his analysis how the shape and size of a body would impact his conclusions. And I'm over here thinking, yeah, how is this allowed? In my opinion, the failure of Dr. Chang's model to account for the variable of the shape and size of the body moving through the water was fatal to any conclusion he might have reached as to the movement of the bodies in the bay. What Mark Geragos is saying right there is it's unreliable, regardless of if he was to even go like my way with it. Like then the state would be able to destroy him, you know? But this just shouldn't be allowed, period, because he's saying he's not an expert. So therefore, if he's not an expert in this field, you're not allowed to. The only time that opinions are allowed in court is through an expert. Okay. Otherwise, it's speculation. Okay. Like you just can't. It's the rules that calls for speculation. Contrary to my expectation, however, the trial court nonetheless admitted Dr. Chang's testimony as an expert. Well, when did you find this out? I have been advised that the appellate counsel, for Mr. Peterson has argued on appeal that the trial court erred in admitting testimony from Dr. Chang. They did err. I have been advised by Mr. Peterson's habeas counsel that he has contacted an expert, Rusty Fagan, PhD, in the movement of objects in bays and estuaries. I am further advised that Dr. Fagan has signed a declaration for habeas counsel in which he states the following: that he examined the topography of the portion of the San Francisco Bay where the bodies washed ashore and the tidal and weather data in the bay prior to the time the bodies washed ashore. And that based on this data, he has determined that the bodies could have been disposed into the bay at any of three areas. One, near Brooks Island. Two, near the Richmond Harbor. And three, in any of the tidal creeks in Richmond emptying into the bay. Dr. Fagan has further opined that Dr. Chang's opinion limiting the area in which Lacey's body could have been deposited to that near Brooks Island was unreliable. I had no tactical reason for not hiring an expert such as Dr. Fagan, apart from my very strong belief that Dr. Chang, who himself admitted that he was not an expert in the area of the movement of objects in water, would not be permitted to testify as an expert by the trial court. Had I believed that the trial court would find Dr. Chang qualified in the very field he admitted he was not qualified, I would have retained an expert such as Dr. Fagan to review Dr. Chang's opinion and testify to rebut it. I did not make a tactical decision not to investigate or present an expert in this area. On the forensic issue of the canine scent and detection at the Berkeley Marina, this gets interesting. The prosecution provided pretrial discovery disclosing the activity of a dog handler, Eloise Anderson, who brought her dog, his name was Trimble, to the Berkeley Marina on December 28th, 2002. The discovery indicated that Trimble had detected Lacey's scent in the boat launch area where Mr. Peterson had launched his boat on December 24th, 2002. At trial, well, let me see if he goes into it. If not, I'm going to talk about something that happened between the 24th and the 28th. At trial, Miss Anderson testified that she scented Trimble with a pair of Lacey's sunglasses, that she was told to search for Lacey's scent near the boat ramp, that Trimble picked up Lacey's scent in the vegetation adjacent to the boat ramp, and that Trimble followed a scent trail onto the western dock adjacent to the ramp and to the end of that dock where the trail ended. Anderson further stated that it appeared to her that Trimble was following a non-contact trail. That's important. Prior to trial, I understood the highly inculpatory nature of Miss Anderson's testimony. I therefore retained Andrew Rebman, an expert in dog searches, to testify that Anderson's testimony that Trimble detected Lacey's scent trail was unreliable. I moved pretrial to exclude the evidence of dog scent detection as entirely unreliable. I moved to exclude dog scent detection at 3 locations: Mr. Peterson's warehouse, between the warehouse and the highway of 132 along a route from Modesto to San Francisco Bay, and at the Berkeley Marina. Ultimately, I had decided, 1, whether to call Redmond to impeach Anderson at the pretrial hearing, and 2, if that was unsuccessful, whether to call Redmond at trial to impeach Anderson's trial testimony. So those are the 2 things that he had to decide. On February 24, 2004, so this is, the trial court conducted a hearing on my motion to exclude that evidence. Mr. Redmond was presented for the pretrial hearing. So this is again, he's presenting a witness. That's the same thing that Ann Taylor wanted to do. She wanted to present Cy Ray. Okay. Courts allowed. Mr. Redmond was present for the pretrial hearing on the admissibility of Anderson's testimony. Redmond was prepared to testify at that hearing that Trimble's scent detection at the Berkeley Marina was unreliable. After examining the prosecution witnesses at the pretrial hearing, after he examined them, I was satisfied that the state of the evidence required the court to exclude the dog scent detection evidence in all 3 locations. I therefore did not believe that Mr. Redmond's testimony was necessary and did not call him to testify at that hearing. What? What are you doing? Ann Taylor was begging to be able to use her people, right? Here, Mark has them all ready to go, and he just makes the decision that he's not going to call this dude. Now, he explained his reasonings. I'm like, who are you sitting around the table with? Now, he says, guys, I explained my reasonings for excluding the dog scent evidence in my argument to the court. In that argument, I stated that the evidence could not be admitted because the people had failed to establish 2 foundational prerequisites of admission of that testimony. First, Trimble was not certified in vehicle trailing. Okay. Indeed, CARDA, the California agency that certifies search and rescue dogs, did not even have a certification program for vehicle training. Second, and more importantly, the people, meaning the state, could not meet the requirement for admissibility of dog scent identification, that the dog's identification be corroborated by the presence of the quote-unquote target at the end of the trail followed by the dog. As they argued, quote unquote, we don't know what the dog is trailing because, as the courts said, there is no body. There is no human. There is nothing there to test it. I further argued that in every single one of these cases, there is somebody who is found. It is a suspect. It is contemporaneously, like he's saying that my reading of the law in California is that without the contemporaneously location of the target at the end of the search, okay, you didn't find anything. Okay, the dog searches to testify that Anderson's testimony that Trimble detected Lacey's scent trail was unreliable because it didn't cough it up. It didn't end with a body. Okay. So this is him. This is Mark Geragos saying, you guys, laws of California here. The dog goes out. It's unreliable. It's that the dog didn't come back with anything, right? Now, I would have went further, but I moved pre-trial to exclude the evidence of dog scent detection as entirely unreliable. I moved to exclude dog scent detection at 3 locations, right? Ultimately, oh wait, sorry. You could do that again. I think you wrote the same thing twice. Oh, here. There we go. He uses this in as far as case law. After all, at that point, the only testimony the court has is from the handler who says that her dog wagged her tail or behaved in a certain way, which the handler interpreted to mean that the dog had detected the scent of the target person. My reading of the cases simply preclude admission of this sort of fanciful testimony. I do like the word fanciful, Mark. I'll give you that. Fanciful testimony. Although I was prepared to call Mr. Repman at the pretrial hearing to impeach Miss Anderson's testimony regarding the detection of Lacey's scent at the marina, I determined that Mr. Redman's testimony was unnecessary because the law in California was so clear on this point. I decided it was unnecessary to call Mr. Redman at the pretrial hearing. As I predicted at the conclusion of the hearing, the judge excluded testimony of dog scent detection at Scott's warehouse and along Highway 132. The judge admitted, however, the most important part. Tremble's scent detection at the Barkley fucking marina, even though Tremble had not been certified in vehicle trailing and nobody had been found contemporaneously at the end of the dog search. The court decided to admit Tremble's purported detection of Lacey's scent mainly because Tremble's detection was corroborated by the later discovery of the bodies 3 months later at a distant spot in the bay. 1 to 2 miles from the marina. That's crazy, okay? I get what Geragos is saying. Totally agree with his argument, okay? But I'm over here of the opinion that, okay, if you're going to allow this, right, in pre-trial, tell me that she's going to be able to testify to I got 2 things to be kicked, but the one's going to remain. So then I'm going to use that dude at trial, right? And in 2003, why isn't this being recorded? Like, where's the video? It's not like it's 1980. Although I was prepared to call Mr. Redman at trial to impeach Miss Anderson's testimony regarding the detection of Lacey's scent at the marina, I determined that Mr. Redman's testimony was unnecessary. Between the pretrial hearing on the dog evidence and the trial, the prosecution provided me with a videotape of a training Mr. Redman had conducted in 2002 for dog handlers. You guys, the prosecution provided me with a videotape of training Mr. Redman had conducted in 2002 for her dog handlers. Miss Anderson attended that training. At the training, Miss Anderson told Redman that Trimble could successfully follow a non-contact vehicle trail, a claim that Mr. Redman strongly doubted. Mr. Redman therefore devised a blind test for Anderson to prove her claim. The test of Trimble attempting to follow a vehicle trail was videotaped. The videotape graphically showed that Anderson and Trimble failed to follow a subject in a vehicle trail. Ready for this? This was considered exculpatory. Okay, this is why the prosecution had to turn this over. Do you understand that Mark Geragos did not find this tape? The prosecution provided me with a videotape of a training that Mr. Redman had conducted in 2002. You're just going to sit here and tell Mr. Redman never told you, hey, that woman is so full of shit. I tested her bullshit. And her dog completely failed. I know we have it somewhere here on tape. It was how does Mark Geragos not already know this? I think that the prosecution turned it over because the prosecution thought that Mark had it. And so what he did at trial is he played the video, I believe, for the jury. In cross-examination of Miss Anderson, I showed her the videotape failing the vehicle trailing test. I believe that the videotape caused Miss Anderson to lose credibility with the jury. it seemed unsuccessful at that point to call Mr. Rebman for the further impeachment. Well, I would have still called him and I would have said, why did you even do this? Because she was adamant that her dog could do this. I would want to like even more just because at that point I wouldn't even want to just impeach her. I'd want to go after the prosecution. I'd want to say things like, you didn't provide me with this tape, did you? No. Who provided me with this tape? Well, you provided me with the tape. Then I asked you where you got it from, and you told me the prosecution. But I would somehow try to get that out there that that even after the prosecution knew that that tape existed, they still put her on the stand to testify to what she was testifying to. And I would be using that, like, it's not just to impeach the witness, it's to show, like, it's exactly to show what Karen Reed's defense team did with Hank Brennan. Okay, what Alessi did, all right, is to show the jury that these people are lying cheats and they'll do anything for a conviction, even if it's not the right person. So I still would have went and had him, because it's not just about him at that point. It's not even just about her at that point. It's about the prosecution. Again, people can say, I just would be very thorough, like direct to the point. But to think that Mark didn't even have that video. Okay, now we get to the best part of this declaration, and the part that I've been waiting to hear about for 22 years. I followed this case extensively in college, and then continue to follow this case all the way until present day. I've caught so much shit because I've defended this case in terms of, if there's ever a case that's out there where somebody was convicted off of no physical evidence, that's Scott Peterson. Okay. Literally nothing was at that house. Nothing was in that boat. Okay. When you're taking swabs of tarps and you wrap somebody up and you're transporting them in a tarp or a boat cover, and then in a boat, and then you think that you're going to be able to, that boat's tiny. It was just absurd. It was absurd. And so I've caught in a lot of shit over the years because, Lana, you think I know Scott Peterson's innocent. I don't think. I know. But if I was a juror, if you want to go based off of the law, Scott Peterson should have been voted not guilty. Let's find out why he wasn't. Nancy Grace. At the beginning of Mr. Peterson's trial, I gave an opening statement in which I told the jury that it would hear from several witnesses who would testify to seeing Lacey walking her dog Mackenzie after Scott left the house to go fishing. I told the jury that this testimony would establish that Lacey was alive when Scott left and that he was therefore innocent. I did not call these witnesses to testify. What? Right? When you see that, you're just like, exactly what? My reason for not calling these witnesses are as follows. Mr. Peterson left home on December 24th around 10 a.m. Well, that's not accurate. Scott's computer was turned on at 10 a.m. for the record. The Peterson's neighbor, Karen Cervez, testified that she found Mackenzie in the street with his leash on at 10:18 a.m. on December 24th. Karen put the dog in the Peterson's backyard and closed the gate. Okay, she didn't hand the dog off to Lacey. Okay. She didn't hand the dog off to Scott. She just put the dog in the Peterson's backyard and closed the gate. Based on the timing of Mr. Peterson's departure, and Karen finding Mackenzie, I believed that any credible sighting of Lacey walking the dog had to have occurred between 10 a.m. and 10:18 a.m. After my opening statement. Okay, so but let's back up. So before your opening statement, you would have known this, right? If you believe this, if this is your thought process, before the opening statement is made, you would have known this. Right? Right. So then why are you saying it? If he says this next part. After my opening statement, members of our defense team, including myself, interviewed the people who claimed to have seen Lacey walking the dog on December 24th. These witnesses uniformly stated that they saw Lacey walking the dog in the morning after 10:18 a.m. Their statements did not coincide with Karen's testimony, and I therefore decided that the jury would conclude that the witnesses were either mistaken or not credible. Well, this is back in 2003, and 2002 was the year, but it was right there at the end. And how Karen gauged this to be exact, like you'd want to go, like, you're going to have a little bit of time both ways. But you would have known this before you would have said this, if that's truly what you believe. Okay. Their statements did not coincide. Okay, blah, blah. I have been advised, though, that Mr. Peterson's habeas counsel has interviewed the witnesses who claim to have seen Lacey walking her dog on December 24th. I am further advised that these witnesses have signed declarations stating the following. The witnesses confirmed that they saw Lacey walking Mackenzie in the late morning of December 24th. Several of the witnesses stated that members of the defense team believed their statements were not credible. So look at this. Several of the witnesses stated, okay, the defense team. Several of the witnesses stated that members of the defense team believed their statements were not credible because their timing was inaccurate. That is, the defense believed these witnesses must have seen Lacey walking the dog between 10 a.m. when Scott left home and 10:18 when Karen found Mackenzie in the street. When these witnesses insisted that they saw Lacey later than 10:18 a.m., they were not contacted by the defense again. So they got the Innocence Project talked to these witnesses. Now, if you actually go and you read the book, Presumed Guilty, by one of Scott Peterson's, he wrote this book in 2005, and he said, right here, he says on page 3 of his book, okay, what happened to the information I'd uncover about the van that was sitting across from Lacey's house the morning of the 24th and was later seen speeding away from the area where she was last seen walking? The pregnant woman who was being terrorized in the neighborhood, the numerous other pregnant women who disappeared in the area, the crime spree in Lacey's neighborhood that started hours before she disappeared, the screaming coming from the park bathroom where Lacey was seen walking the morning of December 24, 2002. Where was there, or why was there no testimony from the witnesses I'd interviewed who'd seen Lacey with her dog that day? What about the felons who were breaking into the house across the street the morning of December 24th? Okay. I've been advised by the habeas counsel that he located in the discovery provided by the prosecution a handwritten police report regarding an interview with Russell Graybill, a postman who delivered mail to the Petersons' neighborhood. According to the police report, Mr. Graybill told police that he delivered a package to the Petersons' home around 10:30 a.m. on December 24th. The gate to the backyard was open, and Mackenzie was not inside. I am further advised by habeas counsel that several neighbors testified that Mackenzie often got out of the backyard and could be seen running freely in the street around the Petersons' home. Habeas counsel has suggested the following possibility, which I had not considered before or during trial. And this is why every good lawyer needs a very good discovery researcher. Because you would not, and you need somebody that can connect dots or put things to show, hey, well, what about this though? Otherwise, you're not able to make arguments. Like, you can help a lawyer make their arguments. You don't have to know the law to help somebody make arguments. You need to be able to give them the information so that they can back up their arguments. So check this out. He never considered this. Mind-blowing. In light of the handwritten report describing Graybill's statement to the police, 1, Mackenzie might have gotten out of the yard soon after Mr. Peterson left the house, as several witnesses testified was not uncommon. 2, that Karen could have returned Mackenzie to the backyard around 10:18, and that 3, Lacey could have subsequently begun her walk with Mackenzie after Karen returned him to the backyard at 10:18. Like, duh. You want to know why it's duh? Because people are telling you that they saw her after 10:18. So right there, you would try to figure out, like, why are these people saying that they saw her later? Instead of saying they must be confused, that means that you're believing in some type of way that you think Scott Peterson is guilty. Okay? Also, the Brita water, like, she was in the middle of doing something. So continuing on, he says, habeas, he says, this scenario makes good sense. This scenario. It had not occurred to me previously because I had not seen the Graybill handwritten police report prior to trial or during trial. I don't give a shit about that handwritten police report. Didn't you talk to this man? But this is why he didn't see it. In fact, I had not seen the report before habeas counsel brought it to my attention in May of 2015. Holy shit, right? The reason I had not seen the report appears to be as follows. The discovery provided by the prosecution consisted of over 50,000 pages. Most of the pages were typed, but some small number were actually handwritten. To organize and access the voluminous discovery, the defense team stored and indexed a digital text searchable copy of the discovery in such a way that we could perform word searches on it. At some point in this process, we became aware that the indexing only retrieved typed pages. When did you become aware of this? It did not retrieve handwritten pages or written portions of a page. So not even just the handwritten pages, but if you had a typed up page and you wrote something on it, it would not detect what you wrote. When we discovered this flaw in our indexing, I instructed our paralegal to hand search the 50,000 pages of discovery for all relevant handwritten pages. It appears, however, that this paralegal did not locate the handwritten report describing Mr. Graybill's observations. I can say this with some certainty because for every witness called at trial, the defense prepared a physical folder containing every reference to that witness from the discovery. It's exactly how you would do it. Okay. And so there would be 184 witnesses. 180. So what you're going to do is so for example, we're just going to use the Brian Kohlberger case. Okay. And here's the state's witness list. This is who they intend on calling to the stand. Okay. You would have taken this, okay, and you would have created a folder for each one of these people, and you would have used like code. You would put the name in, like, I don't know, Douglas, and then every page in the discovery that has his name in it would come up and tell you, and then you would just press print and you'd get every page wherever his name is. Okay. Or you can do it even like better, and you can actually just, hey, I want the whole report of any name, like Michael Douglas. I want every report that he's in. Okay. And then you're going to have on your file folder here whatever the topics were that he was covering. So you would know, because you would want to prep what this person's even going to be potentially talking about. And you want to know if they're saying something on the stand that's just like, wait, that's not fucking right, you know? So anyways, this is how he says he did it. And he can say with some certainty that he knows that the mailman's report, or folder rather, his physical folder containing every reference to that witness from the discovery. Habeas counsel has provided me with a copy of our witnesses, or our witness file for Mr. Graybill. Like all the other witness files, the file was supposed to contain every reference to the witness in the discovery. Our Graybill witness file, however, does not contain the handwritten police report. Had I been aware of the handwritten police report describing Graybill's observations, which supported the theory that Lacey left the house after 10:18 a.m., I would have made a different evaluation of the credibility of the witnesses who claimed to have seen Lacey walking the dog later than 10:18 a.m. I therefore would have called these witnesses to testify as promised in my opening statement. Well, I have one question for you. You would have known all of this prior to your opening statement. So why would you promise that people are going to take the stand? That still does not answer that question. Just because you didn't have that police report, that handwritten police report, right? If you've ever talked to the mailman, right? He said, how do I know he said it? If you wouldn't have gotten to a pissing match with Matt Dalton, you would have been fine. Because he said that the gate, he first of all said when he went there, okay. What was in here? Here we go. Declaration of Russell Graybill. This is the mailman. You wouldn't have needed that report. Mark Geragos fucked this up big time. I don't care what people say. He did. So here it is. In December of 2002, I worked for the United States Postal Service as a mail carrier. My route included 523 Covina Avenue in Modesto, California, the home of Lacey and Scott Peterson. As of December of 2002, this had been my route for about a year. As I recall, 523 Covina had two gates visible from the street, a front gate that led to the front courtyard and the front door, and a side gate that led to the backyard. As a mail carrier, I am very aware of the dogs on my route. Thus, I know who has a dog and whether the dog is friendly or not. As such, I had no problem recalling that the that the dog Mackenzie lived at 523 Covina Avenue in 2002. I also have no problem recalling that Mackenzie always barked at me when I delivered the mail. It did not matter if Mackenzie was in the front courtyard, the backyard, or inside the house. When Mackenzie was at the house, she barked when I delivered the mail. Prior to December 24th, 2022, this is important, I had also seen Mackenzie on the street outside 523 Covina Avenue. On these occasions, Mackenzie would not allow me to walk on the grass outside the home nor approach the house with the mail. Mackenzie would stay on the lawn, and I did not see her go into the street. In fact, about 10 days before Lacey Peterson disappeared, I spoke with her about Mackenzie. There had been a series of packages addressed to Lacey which had arrived around that time. I told Lacey that I had trouble delivering the packages because Mackenzie was in the front courtyard barking. Lacey told me not to worry, that the packages contained baby clothes and I should just leave them outside in the front gate. I remembered the morning of December 24th, 2022 well. I remember this morning well because the Christmas rush was over and the area around 523 Covina Avenue was at the beginning of my route. I'm fresh. On this morning, I delivered mail to the Petersons' home sometime between 10:35 and 10:50 a.m. And he knows this because there are barcode scanners placed on 6 random mailboxes throughout my route, and I scan them as I pass to mark my time and location. That is huge. Shortly after December 24th, 2002, I printed out the computer record for the 24th and my last mailbox scan before I reached 523 Covina was at 10:19. So I'm a timeline person. So you take 10:19, which is he scanned this mailbox before getting there at 10:19. Now remember, okay, Karen is saying that she returned Lacey at 10:18. Okay. So Karen is returning Lacey at 10:18, just puts Lacey into the behind the gate so that she can shut the gate. Okay. From the location of the last mailbox scan, it would have taken me 15 minutes at the very least to reach 523 Covina. So add 15 minutes. Thus, I was at the Peterson's home sometime between, like he was saying, 10:35 and 10:50 a.m. When I arrived at the Peterson home, I noticed that the side gate was open. I did not see Mackenzie, and Mackenzie did not bark. This caught my attention because normally Mackenzie would bark at me when I delivered the mail. When I spoke with police after Lacey's disappearance, I told police that the gate was open. And Mackenzie did not bark when I delivered the mail on December 24th, 2002. That would mean one and one thing only. Okay? That Karen, if she in fact delivered Mackenzie and put her behind the gate and shut the gate, right? At 10:18. He's coming by between 10:35 and 10:50. There is no dog there, okay? And the gate is wide open. So two things means either Karen is mistaken in her time, right? Or Karen isn't mistaken in her time. She returned Mackenzie, and then Lacey and Mackenzie then went out for a walk. Because what we can say, if this guy was to take the stand, when the mailman came, dude, the gate was open. There was no dog that I saw, but more importantly, no barking. The dog always barks at me. You don't understand. This is exculpatory to the utmost. Scott Peterson, okay, was not the last person to deal with Lacey or Mackenzie. But you might have to ask themselves, why did Mark Geragos, who cares if you saw a police report in there or not? You did not know that a mailman would be, oh, hey, let's talk to the mailman. Let's see what's up with the mailman. And what was Mark Geragos doing? So I have looked at a handwritten police report dated December 27th. You know how soon he gave this report? Which memorialized my statements to police at the time. The police report is attached as attachment 1 to this declaration. I testified at Scott Peterson's trial in 2004. What? I said, wait, what? He said, neither the prosecutor nor the defense asked me whether or not the gate was open or if Mackenzie barked on the morning of December 24th, 2002. What are you doing, Mark Geragos? Because this trial was never televised. This whole time in 22 years, okay, because mainstream media put out false shit, I never knew that the mailman even testified. I thought that he didn't testify. Why? So I'm trying to find the line of questioning that transpired that the prosecutor calls this man to the stand for what purpose? If he's not asking, so neither the prosecutor nor the defense asked me whether or not the gate was open when I arrived, or if Mackenzie barked on the morning of December 24, 2002. If I had been asked, I would have testified in accord with my statements to police on December 27, 2002. And with this declaration, the side gate was open and Mackenzie was not barking. Take that, Nancy Grace, and shove it up your fucking ass. You are a liar, Nancy. Who the hell was inside that courtroom? So this is my comments here. Look at this is me. I'm like, if you weren't asked either one of those questions, then here's me. Then what were you called to testify to? Wait, I'm just blown away when I'm reading this. I'm like, what? Mark, it wouldn't have mattered if you had the report or not, in my humble opinion. If I got the mailman up there, I'm going to ask him, okay, were you interviewed by the police? Okay, when was that? Oh, you were? December 20. You were interviewed just a couple days after? And then I would have said, hold on a minute, Your Honor. I would have conferred with the person on my team that was in charge of this man's folder, right? Hey, do we have any police reports? No, we don't have any police reports of him. Well, we have a couple here, I think. Or no, we don't have. Do you recall what you told the police? This is wild to me, because I just feel like even this fuck up, if he's on the stand, like, was he nervous? Did he think that the guy was going to say that he heard Mackenzie barking? Because guess what that means? You don't know your case enough. You don't believe in your client's innocence. You have 15 witnesses that say that they saw Lacey walking that dog well past. And I mean, you didn't don't defense attorneys talk about what they're going to ask this person and why, and be careful because you don't want to ask a question that you don't know the answer to. But Mark Geragos can't claim that this was a Brady violation because the handwritten report was actually in Discovery, but the way that they were scanning for Discovery, it didn't pick it up. So Mark Geragos says. But in the interest of justice, though, this totally outweighs Mark Geragos' stupid ass. This is new evidence, in my opinion. And it's in the interest of justice. The jury never heard this. The jury didn't hear any of this crap. But Mark Geragos literally had a client on death row, literally facing the death penalty. And this is the type of, I don't know, you're supposed to be the best, which means you're a litigator, which means your trial, like you're going to be able to, like that's what you get paid for. Like, why was this man called? Why was the mailman called? So I'm trying to find his testimony. So if anybody has it out there, I send it to my email. What does the police report about the mailman prove that's exculpatory? That the dog wasn't inside the gate. The dog wasn't inside the gate. When Karen went to return the dog at 10:18 and put the dog inside the gate, Lacey and the dog then left and went for their walk. Otherwise, when the mailman comes between 10:35 and 10:50 and the dog's not barking and the dog's not there, where's the dog? That's exculpatory. Okay? The dog wasn't found roaming the streets of Modesto without Lacey. The dog was found put inside the gate, closed with its chain, with its leash still on, and the leash was all like dirty and crap. So basically when Scott would have left, he leaves. The dog's clearly getting out. The jury didn't hear how the dog gets out, and the dog has gotten out a handful of times. And they don't go and tell Scott or Lacey. All they've done in the past is just take the dog and put the dog back behind the gate and then close the gate. So then everybody, Lacey was then seen by 15 people out walking the dog. So that means that Lacey then had to get the dog after 10:18 and then go for their walk. Okay. The reason that Mark Geragos said that he didn't call these people to the stand, yet he told the jury he was going to call them, okay, is because, well, why would you tell the jury that? You already know that time frame is from 10 to 10:18. Like, that didn't come out and like, you knew that. So why would you tell them? It makes his arguments crap. He fucked the dog. He did really, really bad. Anyways, if the jury hears how, okay, when the mailman comes there, he should be hearing the dog bark. Because if Scott Peterson took Lacey because he killed her, Lacey and Scott are gone. After Karen would have returned the dog and closed the gate, the dog would have been in the backyard barking at 10:35 to 10:50 when the mailman is arriving. And the dog is not doing either of that. And the gate is open. The gate is open. There's no dog, and there's no dog in the house barking. No barking at all. That means, where's the dog? A couple people had wrote out stuff that they said that they had seen just a dog roaming that looked just like Lacey's dog. And so if the jury would have heard how, oh my gosh, wait, the mailman comes, there's no dog there at 10:35, and then they hear from the witnesses, and you're going to talk about 15 of them testifying to seeing her walking that day. Can you believe that? Can you believe that the jury didn't hear that? The 15 witnesses, the mailman, it's just, and then these expert witnesses that just got blown up. But mainstream media, this trial was never seen by the people. This was not recorded. This was not, you can't watch every single day. You can't even go back and watch on replay. We had to rely on whoever was inside that courtroom to come out and tell us what happened that day. And all these people lied. Except for there's one dude from ABC, and give him credit, Mark. They should have called the witnesses to set the timeline. Yes. I think that you just got here. Go back and listen to the episode. Next. I want to point out that okay. Well, we're at that 2-hour mark. Here you go. Take a look at this. They started announcing as soon as, look at how early this was. On December 25th, 2002, MPD began broadcasting Scott's fishing location. Detective Grogan testified that MPD issued daily press releases beginning on December 25th. So people out there saying that no one was going to be asked questions about daily press releases, okay? In the Idaho 4 case, right here, Detective Grogan was asked questions about the press releases, okay? On December 25th, 2002, just hours after the van fire was extinguished, MPD issued a press release at 10:30 a.m. announcing that Scott Peterson of Modesto left to the Bay Area to go fishing. On December 26th, 2002, so the next day, MPD issued a press release announcing that on the morning of December 24th, Scott Peterson went fishing in the Bay Area, and Lacey stayed home with plans to stop for dinner and walk their dog at East La Loma Park and Dry Creek. In a televised press conference later that day on December 26, 2002, Modesto Police Chief Roy Wadesden was asked by a member of the media, Chief, was Scott fishing by himself or was he with somebody or was he with someone in Berkeley? You got a leak. It was known by media outlets by at least December 26th that Scott went fishing in the Bay Area as noted in the press release, and more specifically that he went to Berkeley Marina. Look at this. The Modesto Bee. Police seeking to verify trip story. Again, another one of these. By December 27th, reporters had shown up at Berkeley Marina, and they were all around there, including media trucks, because Lacey Peterson had been missing, and there were speculation that if Scott Peterson had been fishing there. Also, by December 27th, the police were at Berkeley Marina interviewing witnesses. The police. They were interviewing people. On December 27th, MPD issued another press release announcing that on December 26, 2002, a search warrant was served at the Peterson residence and that Scott Peterson of Modesto left to the Bay Area to go fishing. Beginning on December 28th, MPD began publicizing the fact that the police were investigating Scott's December 24th fishing alibi. Then they used the term alibi. and searching the bay for Lacey's remains at the daily press conferences. That same day, MPD also issued a press release announcing that Modesto police detectives did conduct a search of a marina in Berkeley. It's a logical step in the investigation in an attempt to investigate all possibilities, said Sergeant Michael Czar of the Modesto Police Department. On December 29th, MPD issued a press release announcing that Modesto Police explained that they are continuing their search, and a search of marina in Berkeley has not unveiled any conclusive evidence. On December 30th, another one. They say on December 30th that MPD issued a press release saying that the police detectives do have a Berkeley Marina receipt from Scott Peterson, Lacey's husband. Dude, he gave them that on the 24th. On the 24th, he gave them that receipt. They are just telling the media that on December 30th that Scott provided that receipt on the evening of December 24th. On January 2nd, 2003, MPD issued a press release announcing that Scott left the family residence in his pickup truck, hooked the boat up at another location, and went to a marina in Berkeley for a fishing trip. It was not a fishing trip, okay? Police are trying to corroborate Scott's trip to the Berkeley area. Get out of here. Look at this bullshit that the police did. MPD had already corroborated his trip to Berkeley. So it appears that the purpose of the press releases was to further alert the public that the police believed Scott was involved in his wife's disappearance. At that point, tips began coming in to MPD reporting sightings of Scott's truck. So again, think about this. You want to talk about flooding a tip line. They flooded. So back in 2022, check out these tactics. They flooded the tip line. They flooded their own tip line. They already knew he was there. They had people already cooperating. None of this should have come out. None of it. Not only does it come out, okay, but then tips of actually sightings of Lacey should have been, listened to, tracked down, talked to those people, go to these areas and look. Is nope. We're not talking about this fucking burglary. We're going to put out Scott Peterson's alibi. And we're going to lie about when we kind of got that information. And now here we're looking for information that we're really not looking for, like the Idaho 4 case, right? But it's going to flood our tip line because there's tips in it that are really, really important because it's all of Lacey sightings. On January 3rd, the Modesto Bee published an article with the headline, "Police Seeking to Verify Trip Story." On January 4th, MPD issued another press release announcing that the search for Lacey continued over to a marina in Berkeley where her husband reportedly was fishing on the day of her disappearance. There is a team of individuals searching the Berkeley marina. On January 5th, 2003, the last date on which the evidence in Claim 1 shows Lacey was likely killed, the Modesto Bee published a front-page article that included a map shown below of the area police suspected they would find Lacey's body. Oh my God, dogs and divers go to work in the San Francisco Bay, Modesto Bee, stating that Peterson told police that he launched his aluminum boat at Berkeley Marina. Then he went northwest and fished around Brooks Island, said Police Sergeant Ron Cloward, who was directing the search. There you go. Area of search. Are you kidding me? They're searching in the water. Okay. Why wouldn't they be searching in the water on December 24th, 25th, 26th, 27th? Like, when do you start searching? As petitioner's defense counsel would later point out, only the deaf and dumb didn't know where Peterson or where Mr. Peterson was that day, acknowledging that everybody knew Scott had been fishing in the bay. A citizen even called the tip line to tell the police that by making Scott's alibi publicly known, whoever took Lacey would have a perfect place to dispose of her body and get away quietly. The prosecution argued at trial that Scott had to be guilty because no one else could have known to put Lacey's body in the water at the location where Scott fished on December 24th, based on the information MPD released to the public on December 25th. And it was not reasonable that anyone would abduct Lacey and hold her for several days before killing her and putting her body in the bay after learning police suspected Scott and publicized his fishing location. In quotes. So let's look at what the press releases say. On December 25th, information was released about the defendant. It said he went to the Bay Area to go fishing. How are these nameless, faceless people, how are they to now, based on December 25th, the day, how are they to know that he went fishing at Berkeley Marina off of Brooks Island and put the bodies exactly where, or exactly there based on this? It is not reasonable. This is what they were arguing in court and saying to the jury. The prosecution further argued, well, let's look at what came out on December 26th. He went fishing in the Bay Area. Well, now they have to have held her for 2 days unless they are clairvoyant or unbelievably lucky that they said, let's take a wild stab and let's look at that map of California and let's look at the entire Bay Area, which is thousands of square miles, and we're going to pick exactly where he went. It's not reasonable. Ready for this? This is where if I was Mark Geragos, I would have said, yeah, exactly. But guess what the police knew? The police knew it all, and they knew it all on December 24th. The police knew where Scott was. The police knew exactly where he was. So the police would be the people that had that information. The Popo. Next one came out on December 27th, left to the Bay Area to go fishing. That's all it says. The prosecution admitted that on December 28th, the first date on which Lacey and Connor were likely killed based on the new scientific evidence set forth in Claim 1, MPD issued a press release publicly announcing that Scott had gone to Berkeley Marina to go fishing. Now, shouldn't one ask themselves, why in the world would the police ever do this, right? They normally would never do this, right? Well, hey, we got to put this out in the paper because if we can then say everybody knew where, anybody and everybody could have known that then, not just us. They're fucking sick, man. This is so sick. This is so savage. This is so savage. The evidence shows that Lacey was killed later. And the evidence shows that the burglary happened on the 24th and the police lied about it and said it happened on the 26th. And that a month later, the Medinas go out and take a $50,000 equity line out on their home. Why? Because nothing in that safe was, nothing in the safe was insured. That's why you have a safe. I want to ask the Medinas if they had jewelry floaters in their insurance policy. Jewelry floaters, which would skyrocket your policy and how much you're paying. Yeah. That's right. All right, guys, we'll see you on the next one. Thank you guys so much. Use the comment section of the video. If anybody deserves another trial right here, I'm fairly sure he's going to get a new trial. Me too. He should get one. He deserves one. And can you believe literally that this man would have been found not guilty if a affair never comes into the equation? This man was convicted of first-degree premeditated murder, sentenced to death off of an affair that happened on somebody sleeping with somebody on November 9th. Pretty wild. Mainstream media, Nancy Grace, I hope this haunts her for the rest of her life, this case. The misinformation. When she was at Delphi, she went into the courtroom, you guys, for all of maybe an hour. An hour. How could Nancy Grace report on the Delphi case from being inside that courtroom for an hour? She set up her little fucking table out there, went live, and then left. She went inside that courtroom for an hour. And then she does the old, I couldn't even stand to be in there any longer. No, Scott didn't get any life insurance policy, nor did he ever call the life insurance policy people. He never made one phone call to life insurance. Yeah. Why would the police need to lie about when the date of a burglary was if these are just meth heads, tweakers? It's because they weren't just meth head tweakers. These were people that worked with the police and they were running organized crime in Modesto. And it's going to come out, and I'm going to love every fucking minute of it. Peace out. Scott Peterson, factually innocent.